Good afternoon, everyone. Welcome to our weekly Tuesday update series. It occurred to me yesterday, we've been doing this for almost exactly 3 months. I think we started on March 9. So I think just in terms of a little bit of perspective, I think folks are really handling this very well. It's been challenging. You know, we're moving into new phases, literally. But as we work through it together, it's been very good to work with folks on this. Thank you to our clients and friends of the firm for working with us, and we look forward to continuing to help you as we progress. We wanted to start off today and kind of really spend a little bit of extra time on the PPP program. We're going to start with Kate Schimmelwick. She's in our Syracuse office. Kate has given us updates previously and has a few thoughts to get us started today.
Thanks, Pete. So last week, I talked a little bit about the Payroll Protection Flexibility Act that, when I spoke to all of you last week, was just at the stage where the House of Representatives had passed it, but we were still waiting on updates from the Senate. So big updates in the past week. So we have now got to the point where the Senate has passed it and the President has signed it as well. The President ended up signing it late last week. So it is now officially enacted into law. So I want to talk a little bit about the changes that the Flexibility Act had on the Payroll Protection Program and how this all intermingles with forgiveness, because that's really the big question here that I'm sure everybody viewing today has, is how does this affect my forgiveness and how do I maximize my forgiveness under these new rules? So as a threshold issue, there's a bunch of changes made to the flexibility that the Flexibility Act made to the Payroll Protection Program. The biggest change, well, they're all big changes really, but one of the largest changes that we had was changing the covered period from 8 weeks to 24 weeks. I'm going to talk a little bit more about that in detail. But when you're looking at forgiveness, we have a few different questions to look at. And so the first one is really, what costs are eligible? Payroll costs are eligible, non-payroll costs are eligible, and that has not changed. However, when we're looking at payroll costs, there's a cap of $15,385 per employee for your payroll costs that are eligible for forgiveness. Talking about the change in the covered period, we don't know if this cap's going to change now. We've talked a lot about that cap in the past couple of webinars, but now having a cap that was previously based on a $100,000 annualized salary for 8 weeks and now bumping this to 24 weeks, we're not sure yet if the SBA is going to change their guidance on that cap, if it's going to change or if it's going to remain the same. So that's something we're keeping our eyes on, and we're going to let everybody know once we find that out. So something to keep in mind. Bonuses are part of payroll. That has not changed. In retirement and health insurance costs for self-employed individuals are not part of payroll costs eligible for forgiveness. Non-payroll costs eligible for forgiveness. So you've got rent, you've got utilities, and you've got mortgage interest payments. That has not changed. However, what has changed with the new act is we previously had this mix of 75% payroll costs and 25% non-payroll costs that had to be used for your loan. That was never really in the CARES Act. That was an administrative requirement set by the SBA. The Flexibility Act has changed that. So they've now changed the threshold to 60% of your payroll cost. 60% has to be used on payroll costs, 40% now can be used on non-payroll costs. So that gives borrowers a lot more flexibility with how to use their funds that better works with their business. The Flexibility Act contained a cliff. The language in there was read to really state that if you didn't use 60% of the funds on payroll costs, there was no forgiveness at all, which is one of the things that this time last week was holding up the passage of the act in the Senate. The senators kind of came to an agreement that they thought that this could be fixed administratively, which yesterday the Department of Treasury and the SBA issued a press release stating that they know that some of the previous guidance, including the application itself, has now become stale because of the changes to that. They will be issuing a new application and new guidance. And they indicated that some of the new guidance will clarify this cliff issue, and that it's expected that there will not be a cliff. So if you do not use 60% of your loan proceeds for payroll costs, it's just going to reduce your forgiveness. It's not going to prevent you from getting forgiveness. So we are keeping our eyes on that as well. So besides what's actually eligible for forgiveness, the next question is usually, when can I use my money? So as I started the webinar talking about, the 8-week covered period to use your funds has now been extended to 24 weeks. You don't have to extend out to 24 weeks though. The Flexibility Act did include language indicating that you can use the 8-week period still, or you can use the 24-week period. What we don't know, and this is a question that I've received a few times now, is we don't know if it's just automatically extended, and if you want to use an 8-week period instead, you have to notify your lender of that, or if it's 8 weeks, then you have to notify your lender that you want to use 24. We don't know that yet. We also don't know if you have to use the full 24 weeks. I think for many borrowers that we've been talking to, there's this idea that really they can use up really all of their funds. They maybe say week 16 or week 12 or week 20. They don't need the full 24 weeks. So we don't know yet if you have to use the full 24 weeks or if you can cut that short and apply for forgiveness early if you don't need it. So during that covered period, you've got different ways to calculate your costs. So when you're looking at payroll costs, you calculate for forgiveness the payroll covered period or the alternative covered period. So the payroll covered period starts on your date of disbursement and then ends 56 days later, including the date of disbursement. The alternative covered period for payroll costs would start on the first day of the first payroll period, full payroll period in your covered period, and end 56 days later. It's very important to note that the alternative covered period, if you're looking to use that calculation, is only for employers who pay their employees bi-weekly or more frequently. It does not work for employers who maybe pay their employees on the 15th and the last day of the month, because that's less frequent than biweekly. So that's something else to keep in mind. For non-payroll costs, there is no alternative covered period. It's just the covered period. So starting on your date of disbursement and ending 56 days later, including the date of disbursement. So you could be in a situation where you're doing two different methods. For your payroll, you're doing the alternative covered period, and then for your non-payroll expenses, you're doing the covered period. So that's something else to keep in mind when you're doing calculations. All right, the big topic. How does my forgiveness get reduced, or when can it be reduced? So again, as I mentioned at the beginning of the call, we do have this idea that there is a new application coming, which may change some of the numbers based on this 24-week period. But we think the calculations are probably going to stay the same. So your forgiveness can be reduced in many ways. So one is going to be by your FTE headcounts, or by your salary reductions, or of course not using your funds in that 60-40 split. So for FTE counts, your FTEs are based on a 40-hour work week. So you calculate your average hours paid per week per employee divided by 40, and then round it to the nearest 10th. If you don't want to do all that math, you can use a simplified method, which is assigns 1 for employees who work 40 hours a week, and assigns 0.5 for employees who work less than 40 hours a week. Where it gets tricky is for employers whose employees are really at, say, the 30-hour mark. Assigning 0.5 to those employees may actually put you in a position where your FTE counts are lower than they probably need to be. That isn't really an accurate representation of your head counts. So you may want to do the more complicated math to go and get a more accurate estimate of your head counts for forgiveness. Okay. After you calculate your FTE counts, you then calculate your reduction by dividing the average FTEs during one of your look-back periods. So you've got 2 look-back periods you can choose from, either February 15th, 2019 until June 30th, 2019, or January 1, 2020 through February 29th, 2020. So you look at those levels and then you multiply it by the eligible costs or loan principal, whatever is lower. So that's your FTE reduction. You also have a salary reduction calculation. So if you've reduced your employee salaries by more than 25%, you're also going to receive a reduction. This 25% doesn't necessarily apply to employees making over $100,000 per the current application. So it's only employees under that threshold. Okay. One of the big changes in the Act was changing the date for the safe harbor. So originally, if employees were laid off prior to April 26 or had their salaries reduced prior to April 26, they had to be restored or rehired by June 30th of this year to receive the safe harbor exemption, to not have to basically do all the math I just talked about. That has now been extended to December 31st, 2020. So this gives borrowers much more flexibility to rehire employees when it makes a little bit more sense based on business levels and based on reopening considerations and what really works better for the business. So that's something else to keep in mind, is this new safe harbor date that's been pushed out. I'm going to turn it over to Jeffrey Shear, who's going to talk a little bit about the new FTE other exceptions that we have. We've talked about this in the past. There's exceptions to these counts that we've discussed, and Jeff's going to talk about some of the new exceptions that the Act has put in place and some considerations about how these changes to the PPP program is going to affect some business decisions about how to use the loans going forward. All right, thank you. Jeff? Great,
thanks, Kate. So it's good to be back here again and talking to everybody. Before I get into the FTE counts, I wanted to just jump on a couple of the questions that popped up. Kate mentioned that retirement benefits and health insurance are treated differently for self-employed people. So those amounts, the health insurance and the retirement benefit costs, are still eligible costs to include in PPP for most employers. Self-employed individuals who apply for forgiveness are not to include those amounts. So the exceptions you mentioned was just for self-employed individuals. So that's one thing I did want to mention. The choice between 8 and 24 weeks, I'm not sure how you are going to make that choice yet. My assumption, and I know I shouldn't assume, but my assumption is that there'll be a box to check on the forgiveness application as to whether you're choosing the 8 or the 24-week period. And I want to get into that in a little bit when we talk a little about consideration. So I'm going to jump back to the FTE counts and the exceptions to the FTE headcount reductions. So in past weeks, we've talked about the reductions if someone refuses to come back or someone voluntarily reduces hours. The Flexibility Act has added in 2 additional allowances. One is the ability to, if you can't hire people back due to an inability to rehire individuals or similarly qualified employee who are similarly qualified to those that you had before, and you have to document that. So if you're in a highly specialized area and you need to hire people that are highly specialized and you can't, that is going to be an exception to the FTE count. The second one, which I think is tremendous and will come into play whether you operate a school or a daycare or a restaurant or entertainment venue or a fitness center, and that is the ability to document, or you have to be able to document an inability to return to the same level of business as of February 15th due to health, OSHA, CDC guidance and regulations. So if there are regulations out there on social distancing, on how far people need to be apart in a manufacturing venue, on whether you can open or not. You know, right now, a lot of restaurants, I know Katie's going to talk about this, but a lot of restaurants have been closed for a long time and you haven't been able to hire people back. the Changes of Flexibility Act has built in a kind of a forgiveness if you're unable to hire people back. That's not going to hurt your FTE count. The important thing there is that you document the inability to return to the same level of work, that you have documentation showing that you can't open, documentation showing that you're a manufacturing facility and you have to have half the people in place that you had before because you have to maintain 6 feet between everybody. So I think that's the important thing to remember on that, is the ability to document the inability to return to the same level due to the guidance. The other important things in the legislation that came out is the limitation on FICA deferral for our borrowers of the Paycheck Protection Program loans was really eliminated. So it was that the deferral was up to the point of forgiveness of the PPP loan. Now that that limitation is gone and you can defer FICA for the rest of the year, half of which would be payable at the end of 2021, half at the end of 2022. You must seek forgiveness within 10 months of the loan disbursement, or it will not be forgiven and you'll have to start repaying that loan amount. For new PPP loans, now this doesn't apply to people who already have loans. The term of the loan can be extended from 2 years to 5 years. That's only for new loans. However, lenders are permitted to amend existing loan documents to go to 5 years if requested by the borrower. So that's something to pay attention to. If you go ask for forgiveness and part's not going to be forgiven, I think you have to proactively ask that the repayment terms be extended to 5 years if you already currently have a PPP loan. The deferral period, if you have a portion that's not forgiven, has been extended from 6 months to 1 year. So if you have a portion that's not forgiven, you do have the ability, again, anyone with a current loan, to request that your deferral go to 1 year and that your repayment go to 5 years, which is that it's not going to be automatic for existing borrowers, and it should be requested. For new borrowers, that is something that will be automatic. Now, just in my last minute here, I just want to talk about some considerations of whether to go from 8 to 24 weeks. I think people should be thinking about how much they've already spent of their PPP funds, how many employees they have, whether if they go to 24 weeks, they can maintain their FTE count for the full 24-week period, because that will be a requirement as far as we know. Think about what phases of reopening you're in and whether you really have the ability to extend for 24 weeks. So there are a lot that's going to come into play when considering whether to extend from 8 to 24 weeks. What I've recommended to a lot of my clients is that you run your forgiveness test based on an 8-week model, and then you run it based on a 24-week model, and you figure out where you can maximize forgiveness. And that's where I'll leave it, and I'll turn it back over to Pete so we can continue the rest of the program.
Thanks, Jeff. This seems to be evolving really basically on a weekly, if not more frequently, basis. I like what you said about running the different models, because doesn't that have to be the way to sort of figure out what's best for each individual business?
I think it does, especially because we were all running models based on a 75-25 split of payroll versus non-payroll costs. So now we're running that based on a 60-40 split on an 8-week versus 24-week. And I think it's imperative. There's spreadsheets within the forgiveness application itself that'll really assist people on running the forgiveness amount that I think people should really take advantage of. And of course, we're happy to review anything that people do just to check for accuracy and making sure you're taking into account everything that needs to be taken into account.
Thanks, Jeff. Okay, so lot going on with the PPP program. Okay, so now we're going to turn to Sam Burgess. Sam is going to provide us with sort of an update on the reopening guidance. This is another thing that's been really evolving on a daily basis with new executive orders, new guidance, and new interpretations coming out. So, Sam, take it away.
Thanks, Pete. So good to be back here to talk to everyone about reopening as more things start to reopen. So just want to start with kind of a current status. So as of today, there are 8 regions in phase 2, with the expectation that Long Island will be in phase 2 tomorrow, and phase 1 for New York City started yesterday. So that's where we stand right now. And in the past, we've talked probably ad nauseum about what's necessary upon reopening, how there's the detailed guidelines for each industry that have to be affirmed, how there's a business safety plan that you have to have complete. So just to start off, I just want to reiterate those, that we need to be following those guidelines. We need to have that business safety plan in place that covers our social distancing, the face coverings, how we're going to clean and disinfect, the hygiene that is available throughout our workspace, the communication and signage that is posted, whether it's signage about social distancing, face coverings, hygiene. We need to make sure we're continuing to do those, as well as have the screening and tracing put in place. So I don't want to go through that again, as I feel like we've talked about that several times, but I just wanted to start with, a reminder of, if that isn't done yet, make sure you get your business safety plan in place and make sure you do affirm those detailed guidelines. So what I want to get into is some important updates that have come out since last week. I'm going to touch on a few of them, and then Katie Anderson after me, she's going to get into some more detail on what's going on in the state as well. But at this time, about a week ago, it was open. Outdoor dining was allowed to open. It was put in phase 2. So if you're a phase 2 region, you're allowed to have outdoor dining. And from what I know, a lot of restaurants have been rushing to get that done, have put things in order so they can have outdoor seating, working with what they do have. So just a few points on that. You have to have open air space without a fixed roof. So you can have a temporary awning, seasonal awning, but it's not your porch that has screens on it that is fixed to the building, that has the roof in there for the whole time. The tables have to be 6 feet apart. And it's not just that tables have to be 6 feet apart, but the tables have to be set up in a way that they're 6 feet from other tables, seats, and patrons. So it can't be set up in a manner that you have 2 tables that are technically 6 feet apart, but then there's chairs in between them. So when people sit in them or back up, they're a couple feet away from each other. If you can't do that, you have to put barriers in place. We've talked about barriers in other situations, how we're going to put those up. But here you can put a 5-foot barrier in between tables if you can't meet that social distancing. Now, as far as the tables themselves, this is one change that's come since last week, as well as there can be a 10-person max at the table. And this does not have to be from the same household. The initial thoughts was it's going to be the same household, you're going to be limited to people you live with. But now, as long as you're in the same party, you can sit at the table together. And to that point, a communal table cannot be used unless the 6 feet can be maintained between parties. So if there's a table for 10, you can't have 2 separate groups of 4 sitting there together if they're not 6 feet apart from each other. Employees obviously have to have the face coverings on at all times. Patrons must have face coverings on at all times, except when they're seated. So your patrons come in to eat, they have their face covering on, you walk them to their seat, they sit down, take the face covering off. The indoor and outdoor seating are closed at this time. That's going to change, and Katie's going to touch on that a little bit with the phase 3, but for this time, indoor and outdoor seating are closed unless it's necessary. Unless, patron needs to use the bathroom, you need to go pay inside, or if the only way to get to the outside is to walk through the inside. That's allowable, and the face coverings have to be worn. And also with that is what we're continuing to encourage the ordering ahead, the online ordering, the contact us, pay and order, like we've been doing this whole time with, takeout, with curbside pickup. Anything we can do to make sure we limit the amount of people that are coming into contact, touching the same things, touching the menus, we're trying to do so. So next is there's been a quick update as well on religious and funeral ceremonies, services. Phase 1, so New York City, 10 people maximum still. Any area that's in phase 2, you're allowed to have a 25% of maximum occupancy for any particular area. So if you have different areas that have different occupancies, each one of them can have 25% maximum occupancy. But you must make sure that other protocols are met as well. that you're socially distanced, that, it's only a family sitting together, they're 6 feet apart from others, that face coverings are being worn, that you're taking out any materials that could come in contact with many individuals, and you're setting up just safe protocols to be followed. Also, you should continue to follow other guidance that's been out there before of how you're going to make sure that this capacity isn't exceeded. Continue remote services if possible. If you can do outside, that's great. Have several services. Come up with some sort of sign up, because you don't want it to be that it's open and then everyone just starts flooding at the same time. So another quick change that came about, which I'll just touch on quickly, is local governments. With municipalities, the way it is now is 50% personnel if you're not in phase 2. And that's going to continue until you meet phase 2. However, once you've been in phase 2 for 2 weeks, which this Friday will be the first 5 regions that entered phase 2, will become on their 2-week mark this Friday, they can then make all non-essential personnel return. So once you've been in phase 2 for 2 weeks, you can make all non-essential personnel return. So that's a big change. Finally, one other thing that has been mentioned by the governor, but we don't have much guidance on, is outdoor graduations. Outdoor graduations are permitted starting June 26th if nothing changes from what we're told. 150 person maximum, but there's no guidance behind that. Does that include students? Is that faculty? Is that just all, and there can be no more than 150 people there? So that's some updates that will be coming out as well. And also, we've been waiting on things to change, and things have been changing just like the PPP on a daily basis, to the point of, new guidance is coming out, new industries are being placed in different phases on a daily basis. Like the outdoor dining came into phase 2 last week. And now there's been information that's been released for bars and restaurants, which Katie will talk about. But there's also, camps in summer camps and day camps were added in there that, just came out of nowhere, and that's added to the, statewide guidance. So it's constantly changing, and there are constant updates that we're keeping our eye on that will continue to change, and we'll continue to update everyone as more guidance comes into play. But for right now, that's kind of the few big changes that happened within the last week, other than the last 24 hours, which Katie's going to get to. So with that, Pete, I'll turn it back to you.
Great, Sam. And Katie may answer a number of these questions in her affirmative presentation, because we're getting a lot here. But if not, we'll circle back with you and Katie at the end of Katie's to catch a few of these. One thing I did want to say, however, before we turn it over to Katie, is that we, again, these are the reopening rules. For municipalities and essential businesses that have been open throughout the pause, you're going to have to look at where you are. And there have been some changes with respect to municipalities and the 50% rule that are in the offing. And we've got a pop-up today at 3. Chris Kurtz is going to do a pop-up webinar today at 3 and talk about those issues. So to the extent that you're a municipality, it's only going to be 15 minutes. You may want to hop on that. So Katie, take it away.
All right, here we go. We have a whole bunch to talk about, and I'm going to do it in 8 minutes. I had an entire presentation planned for you yesterday, and then tons of things happened between then and now that I have an entirely new presentation for you. Lots of executive orders in the past week. This is really just summarizing what is going on right now. New York State Health Department has put out new guidance about what to do with your employees when they show up and they have symptoms of COVID or they've been exposed. I am not going to discuss that today. Instead, at the end of this, I'm going to push out to all of you. I wrote an information memo on this last week. Feel free to read through it. If you have questions, give me a call, send me an email, but we tried to lay it out as easily to follow as possible. Next up, we have the state legislature is returning this week, and there are a number of police accountability reforms that are going through today, and as we speak, voting is occurring. Phase 1, phase 2, and phase 3 guidance, all of which changed, and we will go over. And then finally, we have childcare. So Sam, really had mentioned this. This is just a visual. I'm a visual person. This is where we are right now, and this is where we may be headed. Projected date for phase 3 is June 12th for 5 regions, and it's projected. It's not for certain yet. We don't know. Long Island, projected for tomorrow for phase 2. So hopefully that will be of use to you. I believe this chart will also be going out in another information memo so that you can all look at that in your private time. Moving forward, we have new phase 3 guidance that's been issued for food service and personal care. First thing to look at for these, they all have the same type of a thing, right? It's the crucial elements of all of these. Face coverings, you need to have a face covering. Social distancing, screening, and sanitizing. Now this is, again, these are for phase 3 businesses. And I'm gonna just briefly go over some of these things. The food service guidance, this includes indoor dining at this point. Outdoor dining is allowed, as Sam referenced, for phase 2. One of the questions I saw is, when people are seated at tables, they don't need to be wearing face coverings when they're dining. When people are, customers are up from tables, they need to have a face covering on. That is consistent still with this indoor dining. What's interesting about the occupancy issue with indoor dining is that it's limited to 50% of the maximum occupancy as set by your certificate of occupancy, but this number does not include employees. That's different from a lot of the other places like offices. That 50% does include employees in offices. But this is, again, phase 3 guidance. So just take a look at that. And that is all up on the website as well. And we will be putting out an information memo with more detail on this. Personal care service. Mostly just wanted to break down for you what it means and what it doesn't mean. It includes tattoo parlors, nail salons, massage tables. Can't wait on all 3 of those things. It does not include gyms at this point. It does not include hair-related personal care services. Hair salons need to continue to follow the guidance that's already out there. There will be no beard trimming at this point. But gyms, I don't know what the status is. I just don't know. Maybe guidance will come out and maybe it won't. I wish I had a better answer, but I don't at this point. Moving on, we have, because we got more, phase 1 and phase 2 updates. Now, as of June 8th, higher education research is now a phase 1 industry. So throughout, phase 1, you can have higher education research. Phase 1 and phase 2 now includes curbside pickup for all stores within malls. At first, it was limited to only stores with external entrances. Like in Albany, we have the LLB and has an external entrance to it. Now, I can go wild and get a bunch of stuff from Claire's for curbside pickup. I probably won't, but I may. You now have that option as well if those stores are reopening. Moving on, let's see what else we got. All right, the big one. This is a big one. Child and day camp guidance has been issued. This is statewide guidance. It applies statewide. Remember, childcare is an essential industry, so that can already be operating. But childcare now needs to adjust and operate using this guidance, and they need to affirm the detailed guidance that they are following it. Somebody had a question in there. Where do I find the affirmation? What you're going to do is you're going to go and click on that read and affirm detailed guidance for whatever your applicable industry is. You're supposed to read the whole thing, and then all the way at the bottom, the very last line on the last page is a link. You click that link, it takes you to the affirmation page. You put in your name, your business address, your email, your phone number, you say what industry you're in, and that's it. That's all that's required in the affirmation. Looking to day camps. Day camps right now are scheduled to reopen throughout New York on June 29th. So remember that date for when kids can finally go, do fun things. The 50,000 foot view of this, because there's a ton here I could spend the entire webinar talking about just this day camp guidance. Children are encouraged to wear face coverings, but notice encouraged. Employees have to wear face coverings. They must maintain social distancing from each other. So employees have to stay 6 feet apart from each other unless, it's necessary to be close to each other for safety. You're trying to take care of children. You have to come to, closer contact. But otherwise, the baseline rule is social distancing. What's interesting is that they separate children out into pods, basically, is the name I've come up with for this. Children are to remain within the same grouping of 10, at most 10 per group, right? So say you're at a day camp, it runs for a week, there's 50 kids, 10 kids have to be in one group, 10 in another, blah, blah, blah. The same staff person or number of staff people should be assigned to that same group per day, right? So the point of it is you're really only supposed to be you're limiting the interactions with each other because that social distancing, it's not mandated for the children, but you want to limit the exposure of the kids. So groups should not be interacting with each other. Groups need to be separate, separate mealtime, separate, all of those things. You need to really start thinking about how the layout is going to be different. Looking at recreation, pools and aquatic activities are good. Even though pools have not been widely, that is going to be really interesting that this guidance references pools, but indoor pools are at this point not allowed to reopen unless they've submitted to Empire State Development. Same with outdoor pools. Unless right now you have something from Empire State Development saying that your pool can be open to the public or to whoever, you can't have your pool open. That may change soon. By next week, I might be singing a different tune, or I might be singing the same tune. Looking at, hiking and running, those are the types of activities that are recommended for children. Okay, so we did that. We did the childcare one. One last thing to note. Empire State Development continues to update what outdoor recreation is acceptable in New York. Thrilling for me, it includes pickleball. Thrilling for lots of you, I'm sure it includes cornhole, which is otherwise known as beanbag toss. That is, that's great. Hopefully people will be able to get out there. There's no guidance that exists right now about how to safely do these things. I highly doubt that there will be guidance issued on it. Golf has been existing for this long, and there's no guidance about how to safely run a golf course. But, use your best judgment and enjoy flying disc games. And with that, I'm done.
Katie, thanks. I think you answered a number of those questions, both in the in the group Q&A and also during your presentation. But we'll monitor those and take a look and see if there's more that we can get out to people. Shifting gears a little bit, we've had a lot of questions, continue to get a lot of questions on unemployment. And some of those questions are coming more into focus and some remain in flux. So Paul Bueller, who was in our Albany office, has been following these developments closely and has a few thoughts on these. Paul, take it away.
Thanks, Pete. So if we could just move to the next slide, I've got a helpful chart for you guys from the Department of Labor's website, just to give you a very quick overview of basically what the categories of unemployment are right now. All right, well, so there's three categories basically, and then we'll talk very briefly about shared work, partial unemployment. So basically there are three categories. The first is your typical unemployment eligibility. That remains unchanged. Anyone who normally eligible, as in they lost their job due to no fault of their own or they quit for a good reason, is going to be eligible for unemployment benefits and an additional $600 per week. Second category is a category for people who are not typically eligible for benefits. And this allows people who are, say, business owners, self-employed, people who have exhausted their unemployment benefits, basically anyone who doesn't fit into a normal unemployment category can apply, and they just have to self-certify to 11 specific reasons, one of 11 specific reasons. And so those include people who have been diagnosed or experiencing symptoms of COVID-19, people who have someone in their household or a member of their family has been diagnosed, someone's providing care for a family member, someone who has a child in their household and they're the primary caregiver for that child, whose school or daycare is closed due to COVID-19. Those are just some examples of those reasons. And again, those people are going to get the baseline New York State unemployment amount and the additional $600 per week. The third category is basically an expansion to allow an additional 13 weeks of eligibility so that people can receive benefits for up to 39 weeks. It very much mirrors the normal New York State eligibility requirements, basically requiring people to do a job search, that sort of thing. And again, they're going to get the normal baseline New York State amount plus an additional $600 per week. For all of these categories, the $600 per week extra is going to expire on July 26th. But people will still be able to receive unemployment benefits after that. And the expanded categories for people who are unable to work for a COVID-19 reason, or that additional 13 weeks of eligibility, that's going to continue through the end of the year. So people will just, their unemployment benefits will decrease down to the normal New York State calculated amount. So that's just like a very, very basic overview. Those are the categories of unemployment available to people right now. A few things that I'd say were not necessarily settled, but we've seen some guidance. We've seen the DOL interpret some things over the last few weeks that I wanted to address. So the first is shared work programs and partial unemployment. I don't know how familiar you guys are with those, but basically shared work, an employer can participate and designate people who will have their hours reduced between 20 and 60%, and they can receive a fraction of unemployment benefits based on that reduced schedule. Partial unemployment is people who are working fewer than 4 days per week and earning less than $504 in that week. They can also receive a fractional unemployment benefit. It was unclear initially whether these people would also be eligible for the additional $600 per week, but it turns out, yes, they are eligible for that additional $600. A couple other questions we've seen, particularly about shared work. It seems like people are transitioning. They're much more concerned about bringing people back, and they can bring people back on a reduced schedule and start a shared work program. And so a major cause for concern for a lot of people was, what is this going to cost me if I start a shared work program? And through the end of 2020, shared work programs are going to be fully funded by the federal government under the CARES Act. And so it will not affect experience rating. It's not going to be charged back to employers who participate. So that allows you to bring back employees that you maybe otherwise couldn't have afforded to bring back. They can work a partial schedule and they can get some portion of unemployment benefits. And through July, they can get the additional $600 per week. Okay. Another concern that a lot of people have had, can people participate in a work share program while also receiving PPP money? And I can tell you those two programs, not opposed to each other. You can certainly participate, but you would certainly want to perform the same analysis that Kate and Jeff have talked about today to make sure that you're going to get your maximum forgiveness. Certainly a consideration to whether or not you do want to participate, because inherent in participating in a shared work program, people are going to be working fewer hours and are going to be earning less money, and that can affect PPP loan forgiveness. Okay. A couple other things that we've seen out of the DOL that were previously unsettled. A lot of employers were very interested in putting their employees on alternating weekly schedules or temporary furloughs. So they might work 1 week and then be off the next week, work 1 week, off the next, and do sort of an alternating schedule. And we have seen indicators from the Department of Labor that that's okay, that people can receive unemployment benefits in the weeks that they do not work, and receive nothing in the weeks that they do, other than, of course, their normal wages. Those people can apply once. They can just every week that they are not working certify for benefits, and in the weeks that they work, don't certify for benefits. Probably the last big thing that a lot of employers have been concerned about is, as things start to ramp up, I have called back certain employees and they've said, no, I don't want to come back because I'm receiving unemployment benefits. I can make just as much or more money and not have to work. So typically someone who refuses to come back to work is going to lose their eligibility for unemployment. And so you would want to, of course, report that to the Department of Labor, that this person received an offer of reinstatement from you and they refused it. There is a small set of circumstances where that person can still receive unemployment benefits. And it's basically if they fit into one of those 11 categories where they are unable to work due to COVID-19. The Department of Labor has come out and said if someone fits into one of those 11 categories, they are permitted to refuse an offer of reinstatement. And again, if that's the case, you'll want to talk to Kate and Jeff about possible PPP loan forgiveness and how that refusal is going to affect your forgiveness if you receive PPP money. So the biggest thing now that I think is unsettled is really going to apply to those of you out there that are self-insured nonprofits. So the CARES Act provided for self-insured nonprofits, they were going to get a 50% reimbursement for the New York State amount of unemployment benefits. There are two ways that reimbursement can work, and the Department of Labor said there's two calculation methods. We just don't know yet which calculation method they're going to use. So the first option, they can charge employers the full amount and then wait for reimbursement from the federal government to come in for that 50% reimbursement and then pay that back to the employer. So that would require self-insured nonprofits to pay out the full amount that they were normally expecting and wait to get the other half of their money back. It's also possible and perfectly allowable for New York State to just charge you 50% and then wait for the federal government to pay them the other 50%. At this point, there has been no indication from New York State which method they've chosen. But I can say, because everyone should be getting their second quarter charge statement over the next several weeks. Hopefully, when that comes out, we'll have a little better idea. We'll know if people are being charged the full amount or half. But of course, whichever method they use, ultimately you will get your 50% back if you're a self-insured nonprofit. So I think those are the topics I wanted to cover, and we can handle some questions, or I'll pass this back to Pete.
Oh, thanks. Just real quick, we did get a few questions about fraud, and I know that's come up occasionally with some of our clients as well. I think with the number of people that are applying and the speed with which these things need to be processed, we have seen some of that being an issue. If you get notice of one of those, you should report it to the fraud unit. Is that correct?
Yeah, so there is a fraud division of unemployment. If for some reason you become aware of someone who's receiving benefits who shouldn't be, and we've seen this, certainly there are people who are applying who are not eligible, and the Department of Labor mistakenly gives them benefits. There's also, we've seen that some people are applying under other people's names in an attempt to receive benefits, and absolutely that should be reported to the fraud division of the Department of Labor. They have the ability not only to claw back the money that's been paid out, but also prosecute people criminally in the event that they have affirmatively committed that sort of fraud.
Okay, thank you. So that's going to do it for us for today. We are going to send out to all the attendees the link to the pop-up webinar this afternoon at 3. Again, that would be of primary interest to municipal employers, and it's going to be 15 minutes just talking about the reopening and ramping up and the executive orders on that front. Thank you all for being with us again today. Thank you all for being our clients and friends of the firm. Everybody stay safe out there, and we'll see you next week. Take care.